Video 11, just going to do a little bit of a law perspective. And so I'm going to begin with a mouthful and the exact same way. And in an attempt at non-fictional expression, perhaps word art to some, but most commonly word salad to many others. And I'm doing this for the want to arrive in objective reason, so as to support this ELS material, namely to begin questioning what is law, in order to locate its true power, and so yours, purposely hidden and made obscure, albeit, concerning a secret trust that is being veiled in plain sight. That's what we classify as the unseen matrix, which is available for all who are ready to stand in the self-proximity of their own intrinsic will as a creature of nature, that which exists before any social contract. All variances which serve as evidence of interpreting the system, those whom are first not made immediately aware of this before mentioned power concerning learning what is law, those made up of divided groups consisting of either freedom interpreters or asylum seekers, who next spend their time researching the public narrative of codes knowingly made up of world religions and beliefs, clandestinely controlled through a language of symbols and secret orders. All the while, these same people belonging to these groups inadvertently enforce an obligation attached to the land according to the law by means of adopting these type platforms. Public evidence is obtained by their own enumerated actions, constituting this personal foundation of acceptance through the assumption of communal liability, which within itself serves to prove an obligation that is maintained and continually nurtured by this unsigned social contract. A series of links of implied agreements do form the chain. The hidden obligation is attached to the right of use of that which is being offered, necessitatively embossed upon every descending level of rights to the use of land. This obligation is found within the modern world of estates, which act as a core security for all men to be assured that their agreements with another are measurable against the objective standards noticed within the English law system of land holding. Every tenant holds, but does not own in the strictest sense, that right to an area of land they command as having season or possession in allodium. To accept either or both removes one from the right to exercise the intent of the law. We know today that any citizen subject to English law holds but does not own in the strictest sense when we're referring to land. The largest or highest of the freehold estates is the fee simple absolute, written down by the late Borlaskin, who was once a Justice of Appeal for the Supreme Court of Ontario, Canada, and former professor of law at the University of Toronto, who goes on to next affirm the intent of the English law system. And so, continuing on with this opening statement, he interprets, the holder of an estate in fee simple absolute is, for all intents and purposes, an absolute owner, although technically he is a mere tenant of the crown, unquote. I now read from the paper published by Barbara Pierre, under the supervision of the late Professor Ernest Caparros, who was professor of law at the University of Ottawa, titled Classification of Property and Conceptions of Ownership in Civil and Common Law. Barbara, a lawyer and member of the St. Lucia Bar, so a Roman civil law litigator, opens the introduction with these words: trite though it may be, that the common law has no specific concept of ownership as is found in the civil law, unquote. What is freedom, then, or why seek asylum from one's own agreement? A quandary of self-reflection, most certain. Through comparison of the English land tenure system versus the Roman civil law, that civil law still used by the French, a system of codes now under pressure to accept the greatest English institution known in law, called the trust, serves as a benchmark by its relative adoption of this type law. Its main purpose was to automatically automatically remove the obligation attached to every single piece of property, caprial or incaprial, a prerequisite of feudal, ancient, and modern tenure, whereby those who next doubt this omnipresent bond as a member of English law, through the consequence of being born in the USA, are returned in reason, whereby it is only the propagandized citizen who has mentally left the crown, whereas the USA's adherence to the English law has otherwise made claim to no such idea as the crown serving fiction. You should be learning, you have a life estate. Why not begin from here? You cannot be seen as having any rights within English law unless made mandatory from the event of birth, whereby an invisible hand has branded upon you since this registered events, like livestock belonging to a jurisdiction of a particular herder, the capacity of a tenant. You are using this mandatory capacity right now, which we have also learned is then further subdivided into power and duties through the means of status and subject matter. Is this a good thing? Without rights to the rule of law, would it not prejudice you at birth if you were first without the right of use to this capacity, which is absolutely a necessity in order to hold any estate interest in land? Law of domicile, for instance, is an involuntary act sanctioned through an act of law, not an act of parties, which identifies most importantly a deeper connection to a particular legal system, a phrase accredited to AI, that establishes one's physical presence and intent through providing an identification of jurisdiction by means of interpreting these key features. Inclusively, these features consist of origin, or birth, or choice. The gift of this choice extends itself to the level of knowledge one possesses concerning their comprehension of what is law. Law, in which I have stated, is being perfected through settlement of the originating common law interest. What you should come to fully realize through these ELS videos is that every interest in land is, for greater certainty, held by another, and technically there is no such concept in English common law as ownership. That principal concept, which would otherwise determine that a land interest is to be held in one's own right, holding an allodium title, basically, which then would be contrasted against the explanation of what is feudal land tenure system that is still in full operation today, minus the seized in service condition. Yet, as we have learned from examining today's fundamental tenure, namely that of free and common sockage, we know for greater certainty it stands representative of a hierarchical system of landholding that places at the apex Crown R, that monarchical structure that holds the common law right to land, i.e. the final word over the legal title to land, which then notice the fragmentation into legal and equitable interest. For who, we ask? For and on behalf of the people, in consequence of the need to perfect the law through tenable reason. Is law to descend from nature, natural law, not the laws of nature, if laws to be principally arrive in reason? Reasoning can be traced to legal scholars and historians, men such as Bracton, Littleton, Coke, if you were pronounced it as written, Blackstone, Maitland, Holsworth, and Putney. Those who have become our individual points of reference so as to next begin a quest into the ancient era, that period immediately following the feudal system era, which then describes the purposeful installation of a constitutional monarchy, the result of the Glorious Revolution, its conclusion being the promulgation of the Bill of Rights, 1688-89, whereby Crown R acts as trustee supreme under the English law land tenure system that acts as our individual and collective measure to interpret the law, which affects the people's confidence in this institution, an institution seated upon the power and duty to hold the people's land interest, immediately or immediately. With that, I conclude this loquacious induced oration, to now introduce the topic of the next video that begins with identifying the core drivers that become the progenitors for the basis of all land laws, now absorbed within the common law and equity. If you like this, you know what to do. Have a great day.